Now we're going to move on to employment and labor law. Now, employment law refers to the whole panoply of state and federal laws that govern the employment relationships. And usually we divide employment law and labor law up. Labor law has to do with the bargaining and labor relations between companies and unions. Employment law is pretty much everything else that has to do with the employment relationship. So let's start by looking at labor law, which, as I said, is the union-employer relationship. Now, collective bargaining refers to negotiations between employers and groups of employees, traditionally a union. Unions have the ability under the National Labor Relations Act to engage in collective bargaining, and employees have the right to bargain as a group and to establish, join, or assist labor organizations or unions. And the employers, once a union is formed, have to bargain directly with the employees' representatives. The Act also prevents employers from interfering in employees' efforts to organize or their efforts to engage in union activities. There are also guidelines to the kinds of activities in which employees and employers may engage, including picketing and strikes and lockouts and things like that. And the National Labor Relations Act generally applies to all employers with businesses engaged in interstate commerce, and the National Labor Relations Act is governed by the NLRB, the National Labor Relations Board, which helps to resolve disputes between employees and employers and makes initial rulings, which, as I said earlier, can be then appealed into court. Okay, so that's labor law. Now let's turn to other sorts of employment-related law. And let's start with minimum wage and child labor. So there's a thing called the Fair Labor Standards Act, which established a federal minimum wage requirement for employers. It also establishes policies for overtime pay for full-time and part-time workers employed by both private entities and the government. There are some employees who are exempted, such as professionals and executives. It also doesn't apply to certain small businesses. But otherwise, the FLSA does set general minimum wage standards. And it also protects against child labor by preventing employers from hiring children under 14 or even children over 14 if it's during school hours. And it prohibits employers in hazardous industries from hiring children under 18. The Family and Medical Leave Act requires the government and certain private employers to give their employees leave for certain family and medical emergencies. The employers have to provide employees with up to 12 weeks of unpaid leave for a serious health condition, the birth of a child or an adoption, or the care of a spouse, child, or parent with a serious health condition. It's unpaid, but the employer is required to allow the leave and then allow the person to come back afterwards. And they have to provide them with the same or equivalent job when they return. Workers' compensation laws are designed to ensure that employees who have work-related injuries get some sort of compensation for them without having to go into court and litigate them. So each state has a workers' compensation statute, which is essentially an insurance statute. All companies pay into the fund based on the number of employees they have. And then the fund is used to pay out on a set schedule if a worker is injured on the job. The good news for workers is they don't have to sue. The bad news for workers is that the statutory reimbursement rate is relatively low. But the idea is that it's a compromise so that the employer and the employee don't have to engage in litigation over most workplace injuries. The unemployment compensation statutes provide employees with compensation for a set period of time when they become unemployed. and it's really a combined federal and state insurance program, pretty similar in certain ways to the Workers' Compensation Fund. Companies pay into the unemployment insurance fund based on the number of employees they have and the number that have been laid off in the previous years. And then that fund is used to provide benefits to employees until they find another job up to a certain maximum number of weeks. The Social Security Act was enacted to provide retirement and disability benefits to employees, as well as benefits to survivors of employees, and the Social Security Administration oversees implementation of that program, and the funding for that comes from taxes that are levied on both employers and employees pursuant to the Federal Insurance Contributions Act, sometimes known as FICA. Workers also generally have retirement benefit plans, at least many of them do. There are two forms of retirement benefit plans, or sometimes called pension plans. There are defined benefit plans and there are defined contribution plans. Defined benefit plans used to be very popular. They now are much less common. And here, employers make payments to retired employees based on the length of their employment and the wages they received. And there's a schedule and they get the pension and they're guaranteed a particular amount. Defined contribution plans, which are, as I said, more common now. Those are plans in which both employers and employees can make contributions to an employee's account, and upon retirement, the employee receives benefits from that account, and the employee usually has some ability to choose where that account gets invested. 401k plans are the most common form of defined contribution plans. Now, federal law generally governs these plans, and in 1974, Congress enacted a statute known as ERISA, the Employee Retirement Income Securities Act, to regulate private pension plans. It doesn't require that you have these plans, but it does regulate employers who are engaged in interstate commerce that have one of these defined benefit plans. It doesn't regulate the 401k style, but it does regulate the older form, the basic defined benefit plan. Workplace safety statutes. So both federal and state laws regulate the workplace to ensure a healthy and injury-free work environment. The primary federal statute here is OSHA, the Occupational Safety and Health Act, and it applies to all employers who engage, again, in interstate commerce, because, as we've said, Congress can't regulate it if it doesn't have to do with interstate commerce. And we have OSHA, the Occupational Safety and Health Administration, which administers the act and comes up with various workplace safety standards, can inspect and investigate workplaces, can issue citations against employers, and impose civil and criminal penalties. The biggest part of employment law, though, is employment discrimination law. And there are various anti-discrimination laws that exist, of which the primary one is Title VII of the Civil Rights Act of 1964. And under Title VII, you can't discriminate in the workplace based on age, religion, disability, sex, race, or national origin. It's unlawful to discriminate on such bases in all aspects of employment: hiring, firing, recruiting, compensation, and so forth. And it also prohibits employers from retaliating against employees for filing a discrimination complaint. Now, as part of that prohibition against sex discrimination, Title VII also prohibits sexual harassment in the workplace. And there can be two different kinds of sexual harassment. One is what's known as quid pro quo practices. So an employer could request a sexual favor in exchange for providing an employee with some sort of an employment benefit, a raise or a promotion or something like that. That's quid pro quo sexual harassment, but you can also have sexual harassment that is not that, but creates a hostile work environment. And that's an atmosphere where employees are subjected to a pattern of severe or pervasive, unwelcome sexual behavior or advances. So it doesn't have to rise to the level of quid pro quo. It can be a hostile work environment, and it would still violate the Title VII. The Equal Pay Act prohibits differences in wages based on sex. There's also the Age Discrimination in Employment Act, which prevents discrimination against employees who are 40 years old or more. The Americans with Disabilities Act prohibits discrimination against certain employees with mental or physical disabilities and requires that employers make reasonable accommodations for employees who do qualify as disabled. The Pregnancy Discrimination Act prohibits discrimination based on pregnancy or childbirth. And for all of these, we have the Equal Employment Opportunity Commission, otherwise known as the EEOC, which issues rules and guidelines aimed at ensuring the effective implementation of all of these anti-discrimination laws.